What is due process? The Due Process Clause in the Constitution states, "Nor shall any state deprive any person of life, liberty, or property without due process of law." These words have as their central promise an assurance that all levels of American government must operate within the law and provide fair procedures. The Constitution states only one command twice, and this command is the Due Process Clause. It's found in both the Fifth Amendment and the 14th Amendment, and applies to two different sectors of government. The Fifth Amendment says to the federal government that no one shall be deprived of life, liberty, or property without due process of law. This was ratified as part of the Bill of Rights in 1791. The 14th Amendment, on the other hand, was ratified much later, in 1868, uses the same clause, as we know as the Due Process Clause, but it describes a legal obligation not to the federal government, but to the states. So why did we have to say it twice? Well, when the framers were writing the Bill of Rights and constructing the Constitution, they intended for the first Due Process Clause from the Fifth Amendment only to restrict the national government. There were a couple of reasons for this. The first was because they figured the states had their own constitutions and their own bills of rights. They could take care of this type of thing themselves. If the states actually wanted to incorporate a due process clause into their particular constitutions, they were more than free to do so. And so there was no reason why they would have to do it within the Constitution if the states had the power to do this themselves. Secondly, they figured the state governments were geographically closer to the people. They were more in tune because they were right in their backyards. Imagine having a central government that was really far away and not really being in touch with the people because there was no way to email, call, or send really reliable mail at that time. And so they figured, the state governments are really right there, and so we don't have to protect people from the government because in the states, they're going to hold their state actors accountable. They're less likely to encroach on the people because the people are right there. They can see what they're doing, and if they don't like it, then they can reverse whoever's in office, and they can make sure that they put in representatives who are going to actually carry out the things that they want to have happen. There are several different actors I want you to be aware of when we're talking about who is restricted in their actions by these two amendments. First, there's the national government. All of the national government's actions are covered. So things that we're dealing with up on that central level are always going to be covered by the Due Process Clause. All of the actions that are taken by the national government must not deprive people of life, liberty, or property without going through the appropriate motions and the appropriate process which is allocated to them. State government actions, I'm going to say most. It's not 100% of their actions, but really most of them have been incorporated so that they have to have that type of due process before they do this type of deprivation. Private parties' actions, on the other hand, are a different story. They're actually not protected at all. And so as a private party, you do not have a right under the Constitution to go to, say, your mother-in-law's house and tell her that she is depriving you of your liberty without due process because she is not held responsible under the Constitution. It is holding the government actors responsible. So say a state trooper came up and did this, then you can say, okay, someone's depriving me from the government. Or a national government actor. Then you can say, okay, you two are bound by the constitutional definitions of due process, and you must act within these requirements. However, when you leave the governmental sphere, it's not necessarily the case. Any private party is not going to have those same requirements put upon them because they're not subject to the same restrictions of the Constitution. And so we came to what's called the double standard in criminal justice. At the time, we had federal prosecutors who had the duty to preserve the rights of individuals. So you had this Fifth Amendment, which says you need to make sure that you absolutely do not deprive anybody of their life, liberty, or property without the due process of law. But the state prosecutors didn't have this. We had a good span of time between the Fifth Amendment and the 14th Amendment where there was this double standard. The state prosecutors didn't actually have to follow these rules because the Fifth Amendment only applied to the states, only applied to the federal government and did not apply to the states. So you can imagine between the two different systems, the two different criminal law systems, how there was this double standard going on and how this was creating problems for the criminal justice system. So the court later incorporated these rights in order to avoid giving law enforcement an incentive to violate the Constitution. They said, we don't want to say you can violate the Constitution in this particular realm because you're this particular actor, so we're going to make sure that there's a way for you to comply, and we're going to do that through incorporation. That brings us to this idea of the Doctrine of Incorporation. What this was is that it's an idea that the rights apply to the states as well as the national government. And these were selectively applied over time. It wasn't an idea that all of a sudden every procedural guarantee that you had in the Constitution against the actions of the national government were going to apply to the states. It actually was selective, and these happened one by one over time. And so this was actually very interesting history to read if you ever get the chance, because different rights were taken one at a time in different cases, which brought it in so that the states did not necessarily have a full set of constitutional guarantees that they had to follow, which were similar to the federal Constitution, but they had a smattering of ones which were very similar to what was going on in the federal Constitution, but left a couple of them out because they had not been incorporated by the court at that time.